All right, so just to address some common questions. To the first one, I already partially answered. So, can automated widgets ensure European accessibility at compliance? Well, no. It is pretty clear in the text of the European Accessibility Act that the human involvement is fundamental and essential in order to implement an accessible website. Applies to testing, but also applies to who implements the website. I don't know, Tom, if you want to add any color to this one.
Yeah, I think I would just echo what you've said. I think that it really can't be understated how important it is to involve humans in the testing. I think something that we've really seen clients have issues with is relying solely on automation and having that widget in the corner of the screen, which provides the basic accessibility accommodations, but doesn't really hit the mark when it comes to complying with the general principles that the EAA is trying to achieve, those four objectives.
Yeah, well said. Tom, do you mind taking
Yeah,
the other few questions?
yeah,
Some probably you already answered to those.
yeah, definitely. So these are some, as I said, we tried to cover throughout the session questions that in the last couple of years we've received, but these are some additional ones. As I've mentioned, EAA compliance requirements do vary, unfortunately, across the EU, and it's really up to the member state that's transposing the rules as to how they apply. They can't impose rules that are below or lesser than the requirements set by the directive, but they can implement stricter ones or more enhanced ones, which are wider in scope or cover additional products. And in addition to the changes that we've seen from, across different markets for the penalties, we're also seeing quite specific rules from certain member states on transparency and accessibility statements, whether that's language requirements or a specific template, or even, in some markets, we're seeing obligations to set out specifically which services or elements of your service are not compliant, or the specific steps you've taken that will make them compliant in the future. So there definitely are some real diverging ways of achieving compliance in each market. But what we haven't seen, luckily, is changes between each market in what is expected technically. And we do think this is a lot of this is going to be based on the Web Content Accessibility Guidelines, version 2.2 AA. That's what we're expecting across the EU. We've not seen any additional technical requirements. And I think that probably makes sense because, as I said, the text of the directive and therefore the transpositions is intended to be quite technology neutral and agnostic and be able to move along with technology as it develops. So it wouldn't make sense to include really specific technical requirements, which could become outdated quite quickly. An analogy there is, we're seeing similar issues come up from an AI and Data Act perspective, where there might be definitions which refer to a specific type of technology, which is becoming so outdated so quickly when it comes to iterative versions of legislation being produced. So that's why I don't think we're seeing any changes to the technical requirements. The next one is which countries' rules apply to my business. So, or a non-EU business serving the EU market. So as I said, if you don't have an establishment, first of all, double check that you don't have one because you may have made this assessment previously. As I said, the establishment rules are not new. They have been around for a long time and they apply to every aspect of EU and member state law. And they they have implications far beyond accessibility on things like taxation and employment rights and employment rules. So it may be that your organization has previously been advised or taken a position that you have an establishment in the EU or in a specific EU country. If you do, great, because that will help determine which rules apply to you. I should say the establishment rules aren't they aren't the holy grail of understanding the application of the EAA. it's largely this concept of establishment applies in relation to digital consumer goods. So there are certain things like product standards, for example, where you would need to comply with the rules in every country. But that's not a new thing. There are various different circumstances where manufacturers, for example, who distribute goods to the entire EU, need to comply with specific nuances in each country. So not new there. But if you don't have an establishment and there's no indication that you've made this decision previously, then it can be the case that you need to look to the rules of every single country. And again, as we mentioned, the technical scope, the technical requirements don't appear to be diverging much, but it is those regulatory obligations, the accountability, the public-facing statements, the language you use, those sorts of things can be quite specific. And an analogy for any of our US colleagues who are on the phone right now, we're definitely seeing this in the US from a data protection perspective. We're seeing privacy laws being implemented on a patchwork basis across US states, and each of them have very different but kind of overlapping requirements. Things like reporting obligations, fairly similar. You might have to report to a particular regulator about a breach, but the way you do it, the language you use, the template you use is different between states, and that is kind of what we're seeing here. Looking at the next one, my organization has multiple websites and apps. Do I need to make them all accessible? So this again goes back to the scope. So understanding which of your services or products actually need to comply. So working backwards from there, understanding if you offer loads of different services online, looking at which ones actually fall within the scope of the EAA, not necessarily excluding those that don't, because obviously providing accessible services and products is something that we do that goes far beyond the requirements of the EAA. But from a strictly European Accessibility Act perspective, you could, in theory, then carve out understanding on the basis that you might not have to make certain services comply with specific rules. But of course, we would encourage you to, where you can, find those efficiencies and apply the accessibility accommodations across services. So no, you don't need to make them all accessible from a legal perspective. It would just be those to which the rules apply. And as I said, there are no rules that are specific to all websites and apps. It really is the type of service you offer, whether it's an e-commerce service, a banking service, passenger transit, consumer banking, loads of different things like that. It's the service rather than the means by which it's delivered. That last one I answered earlier. We've developed various internal tools. Do these need to be adapted? There's nothing specific in the EAA that says you must offer internal employee tools that comply with the rules of the EAA, but there are very likely in your jurisdiction and in various different EU member states to be anti-discrimination laws, employment laws, various other laws which may affect or bring into the scope of accessibility obligations, those internal tools. So the EAA, as drafted in the directive, may not necessarily require you to make those changes, but it might be the case that you already are required to offer certain accessibility accommodations internally.